Good morning, everybody. My name is Henry Green. I will be the presiding judge for our next case. With me this morning, the other judges are Thomas Malone and Patrick McInerney. And our next case is 121546 A.D.T. appellant versus the state of Kansas. Let me get the appearances of counsel. Appearing for the appellant.
Jean Phillips, Your Honor, on behalf of the petitioner appellant.
Thank you very much. And appearing for the state.
Daryl Smith, Wyandotte County District Attorney's Office, appearing for the state.
Thank you very much. Ms. Phillips, do you want any rebuttal time?
Please, Judge, I'd like to reserve 2 minutes.
2 minutes. And are you ready to proceed with your argument?
I am ready, Judge.
Are we ready to hear it?
May it please the court, Your Honors, we are here today because the system has failed A.D.T. and for 3 reasons. The first is Kiana White. But for her conduct, this event would not have happened. She supplied a 13-year-old boy, a boy who, by the way, was doing well in school, no criminal history, no violent tendencies, no gangs, knew nothing about guns. She supplied him with drugs and alcohol for a period of time to the point where he became addicted. And then in April of 2008, she purchased a gun, she bought bullets, she picked him up from school, she got him high on ecstasy, marijuana, drunk on copious amounts of vodka, put him in a car, drove to find Mr. McElroy, gave him the gun and said, shoot. And then she took the gun back, drove him back to her house, and she turned him over to the police, and she was never prosecuted. That was the first failure. The second is the failure of the Juvenile Correctional Facility and their obligation to provide A.D.T. with drug rehabilitation. That was the main reason that the judge sentenced him under the EJJP, was so that he would get rehabilitation, and that just never happened. The judge emphasized it. KJCC actually, even through their own metrics, said that he's addicted to substances and that he needs to participate in 2 different kinds of rehab programs, and that never happened. He is released and he has a relapse. Then at the revocation hearing, the third failure is that of the attorney who represented him at the revocation hearing and in the Kansas Supreme Court failed to provide either court with a legal remedy to the imposition of an unconstitutional sentence, a remedy that was readily available. Instead, she filed a 4-page brief to the Kansas Supreme Court, and she argued that the revocation was unjust. And while that may be true, the problem is that, as the Kansas Supreme Court said, we can't reverse something because we think it's unjust or unfair. You have to give us a constitutional argument for it. They repeatedly asked for that, an oral argument, and she had nothing. And so the court said, based upon the issues in this appeal, we have no choice but to affirm, and so they did. She provided no explanation. So we've got failures all the way through the system that led to to A.D.T. serving a 25 to life. There are 2 things I want to keep in mind before I head into the actual arguments. And one is that the basis of the district court's opinion in this 1507 is almost exclusively that because there is no on-point case law, that the attorney below was not ineffective. And I take issue with that because you don't have to have very fact-specific on-point case law in order to make the arguments. Due process sets out legal principles. The 8th Amendment sets out legal principles. And then the question is, do the facts of your case violate those legal principles? She failed to make those conversations or have those conversations or rule on that. The second thing is, oddly, while the state agrees that the sentence in this case is unconstitutional, they have contested the ineffective assistance of counsel. And the argument that was raised at the 1507 hearing was essentially that the attorney raised the arguments that we're raising. She just didn't use magic words. But of course, that's exactly the point. She didn't put it into a constitutional framework that would have allowed the Kansas Supreme Court to reverse. And I would encourage you to hold the state to that argument, right? That's the only argument that they have presented, and they should be held to that and not allowed to shift gears at this point. So the first issue in the brief is jurisdiction. That issue, I think, goes away, right? In Re JSP, the Kansas Supreme Court on June 26th of this year said that there is jurisdiction to review revocations under the EJJP. So the jurisdictional issue goes away, which takes us right to the ineffective assistance of counsel claims. This court is probably very familiar with the ineffective assistance of counsel test, right? Is there an error to the extent that the conduct of the attorney fell below professional norms, and does that error result in prejudice? The one comment I would make about prejudice is that this is not a but-for test. The U.S. Supreme Court is really clear in both Strickland and in Holland versus Jackson that it is something less than a preponderance of the evidence. You do not have to show that the outcome would have been different. You just have to show that we are no longer satisfied with the outcome and that our confidence is not there any longer. So the last sort of point is the de novo review, right? We're not contesting any of the factual findings that were made. We are contesting the legal findings, and we encourage this court to apply de novo review. First ineffective assistance of counsel argument that we raise is the failure of the attorney to challenge the 25 to life as unconstitutional under the 8th Amendment.
Counsel, let me interrupt you with a question.
Sure.
Just to make sure you don't run out of time, I would actually like you to address your last argument first, which might be the simplest argument, and that is that counsel was ineffective for failing to argue that the 2016 amendments could apply to this case. Why don't you address that first?
Sure. So recognizing that juveniles were facing pretty harsh punishments for probation violations, violations that, by the way, mostly adults would not be revoked for. The Kansas legislature in July 1 of 2016 passed legislation that went into effect July 1 that said if you substantially comply with the provisions of the juvenile sentence and not commit a new offense, you didn't have to revoke, right? As long as there was substantial compliance. And so revocation, the result of this case is not final until the Kansas Supreme Court issued their opinion, which came down several months after the imposition of that, or the change in that statute. And counsel says, you know, I wasn't aware of that change in the statute. I didn't know it existed until much later. Our argument is that because those changes happened while this case was still pending before the Kansas Supreme Court, they apply to this case. Those changes are procedural. They are simply changing the steps by which a person who violates the law is punished, right? It's not adding any substantive to it. There is a Kansas Court of Appeals opinion from 2011 where this court said the 2010 amendments applied, right? And by the way, I will note that the 2000 amendments applied in this case too, right? So even though this crime happened at a different time in 2008, they still applied the amendments that existed in 2010 when they revoked A.D.T's probation. So, right, why would those amendments apply and the 2016 not apply? And what this court said in Re IA is that it doesn't prescribe criminal conduct. It doesn't prescribe a sentence for any act. It doesn't alter a substantive act. That the change allows for the juvenile court, and this is important, to have more latitude with regard to the adult sentence, thereby lessening the harsh results, right? That made this procedural only. And if those 2016 amendments are procedural and they're remedial, then they applied in this case, and counsel should have argued them. The district court, Judge York, in the initial revocation hearing said, you know, there is no room for me to say that the technical violations should not result in revocation. Even though I think they should, I don't have room to do that. By the time this case got to appeal, though, you did have right to do that.
Let's assume that we would find, as a matter of law, that the 2016 amendments apply to A.D.T's case.
Right.
What would be the appropriate relief for A.D.T.? And how do we get there from where the case is right now?
Well, there would be a finding of ineffective assistance of counsel for her not making that argument.
Can we make that finding? The judge never got to that, right? The judge found that it was the amendments were substantive and just sort of stopped right there.
Right, she did. I think that this court still has the ability to review the fact findings that she didn't argue, the 2016 amendments. You can review the legal conclusions de novo and say, yes, those 2016 apply, and she should have argued it, right? That's the argument we made, and this court still has the ability to resolve that issue de novo, which would kick the case back. We would go back to the revocation proceeding, and the judge would have to make a decision about whether or not to revoke his probation or to continue with probation. And that's the position that would put her in, or put this case in, back before, I assume, it would go back to Judge York again. Right?
What you ultimately want is a new revocation hearing, correct?
Yeah, well, yes, as to this issue, yes, as a new revocation hearing.
Applying in which the 2016
amendments would apply, right. Right.
Let me ask you one final question. When you were talking about prejudice, and you were talking about it doesn't require a probability, there's as long as the court's not satisfied with the outcome.
Right.
What's your case citation on that?
So Strickland itself, 466 U.S. at 693 says you don't have to prove that it more likely than not altered the outcome. And then Jackson versus Holland is a 2004 case at 542 U.S. 649, and it says the threshold for a reasonable probability is something less than a preponderance of the evidence.
Okay, thanks.
Yeah. And so as long as there is no longer confidence in the outcome, then we reverse it under Holland versus Jackson.
Thank you.
Yeah. So as long as we're talking about remedies, Judge Malone, I would like to go back and talk just briefly, and I know I'm running out of time here. I want to talk just briefly about the 8th Amendment violation. Sure. So based on this court's decision, I want to, take this court to Williams, State versus Williams, which was decided on October 9th, which took all of the case law that has come down through the U.S. Supreme Court from Roper and Graham and Miller and sort of culminated it and said, look, we have got a changing and evolving understanding about juveniles. We know that they're very vulnerable and they're susceptible to negative influences and outside pressures, that they have very limited ability to extract themselves from perhaps pretty dangerous situations, that they have a lesser developed sense of responsibility. And so that makes a difference in terms of whether or not the sentences are unconstitutional. And we're not trying to say, by the way, that this is a straight up Miller violation. What we're saying is that in this instance, not that the EJJP violates Miller, but in this instance, when you look at the concepts of Miller and you combine that with the factors of State versus Freeman, we have an unconstitutional sentence. A fact which, by the way, the state agrees with us. The state says, yes, this is an unconstitutional sentence, right? The chief deputy said in an email to me, which is a part of the record, that we agree this violates and we're not going to challenge you on whether or not this sentence is unconstitutional. We approached Judge York with a couple of different remedies. So one, she could take this back to the revocation hearing and put him back on probation, because then he would no longer have that life sentence, or she could allow the plea to be withdrawn and to plead A.D.T. out to a second-degree murder charge, which would put him on the grid and give him a constitutional sentence.
You changed your mind on that, though, didn't you? You told the judge you weren't trying to withdraw the plea.
No, we said that we had a couple of different hearings, and in that hearing we said we will take that, right? We will withdraw the plea. If you will allow us to withdraw the plea, we will do that. We will put him on grid, and it's like 147 months, which he's going to come pretty close to having met by the time this all gets resolved. And we were willing to do that. And when she said no to that, then we said, okay, if that's not what you're going to allow us to do, my son is telling me my time is up. But she said, if that's not what you're going to allow us to do, then we want to go back and argue ineffective assistance of counsel, right? So either you let us withdraw the plea and put him on grid, and if you won't let us do that, then we go back and we're arguing ineffective assistance and take us back. But ultimately, when you look at the sentence, it is unconstitutional under Freeman, and it's unconstitutional based upon those principles that are set out in Miller, right? And so our argument is that you have to give him a remedy if it's unconstitutional, there has to be a remedy. And you either put him back on probation or you allow him to go on grid. And the only way to get him on grid is by withdrawing the plea and resentencing to second-degree murder. So I am out of time. I will stand on my brief on all of these issues. Thank you.
Mr. Smith, are you ready to proceed with your argument?
Yes, Your Honor. Thank you. I would like to address one of the issues that came up at the end of the previous discussion. Counsel states that the state made a concession that this was unconstitutional, and that is based solely upon an email that was sent by my boss, Mr. Mitchell. And I think it's important that the court understand the context of that email. It was, as I believe Ms. Phillips has touched upon, in the context of trying to resolve the case. And I don't want to speak for how much Mr. Mitchell researched that or not, but I don't believe it was an unconstitutional finding based upon research that was done with respect to Miller. I don't think that we need to concede that Miller applies to this specific situation. Judge, an email, I don't think is something that needs to rise to the level of a legal concession. I don't dispute what Mr. Mitchell said, and he did say that as Ms. Phillips quoted it, and it was a part of the record. But whether or not Miller applies, I think it's Mr. Mitchell's opinion, even at that. And that's not a determination for him. It's a determination for this court and other appellate courts. And I think that
when the district court revoked the juvenile sentence and ordered him to serve an adult sentence, was there any discussion at all at that time about modifying the sentence, which the statute allowed at that time? Was there any discussion at all about that?
Judge, I do not believe so. I believe that was in 2016. And after it was revoked, I don't recall anything from the record about a modification. It was simply an imposition of the sentence. And that does bring me to my other point about JSP and the Rule 609 that I filed with respect to jurisdiction. I think the law has changed in the interim, and this court does have jurisdiction to hear this case. But as far as modifying it back in 2016, I don't believe that there's anything that I could point to in the record that would say that was done. Certainly, it's a massive record. If Ms. Phillips has something in there, I'm unaware of it. Moving on, I would, if that answers the court's question.
Yeah.
Moving on, I think that when counsel says the system failed this juvenile, I think it's important that we remember that the sentence was imposed, as Judge York noted, for the completely unmotivated killing. This was a 13-year-old who, the best we can tell, killed somebody just for the purpose of experiencing killing someone. It was, to say senseless, there's simply no sense to it whatsoever. A 13-year-old who picks a random person and executes them. And Judge York made a point in her factual findings that it wasn't, the sentence itself wasn't imposed, the underlying adult sentence certainly wasn't imposed for the consequences of the revocation. It was for the senseless killing that underlied that. And with respect to all of these claims, I would like to point out to the court, as counsel said, that Judge York's factual findings, which are outlined in her order, which is attached to my brief, are factual findings that this court needs to adopt in its review of the law. And Judge York's factual findings, and in making all of her findings, she has to give deference under the law with respect to ineffective assistance of counsel to the conduct by Miss Erickson. Judge York gave appropriately the appropriate level of deference to all of her findings and conclusions in her order of May 24th, 2019. And this court has to adopt those factual findings. So what we've got is her being bound to give deference and the court being bound to adopt all of those findings. These constitutional claims essentially are the appellant trying to make constitutional claims through an ineffective assistance of counsel claim. And Judge York, I believe, appropriately cited the Edgar case, which shows that there has to be a reasonable probability. And I believe that's on, that is in her opinion, and never found that any of the conduct by Miss Erickson would have resulted in a reasonable probability of a different outcome. She visits each and every claim made by the appellate in this case, and the focus in this case, I think, has been an effort to shift it from the underlying crime to the revocation. But I think it's important to realize that the respondent, A.D.T, was in custody for years and then released and then tested positive and then was revoked. And the results that would have come out of that, I think, were clearly outlined in Judge York's opinion, that none of the factors that could have been raised when she applied the appropriate standards to Miss Erickson's conduct would have made any difference. Judge, I'd ask that the court uphold and give the deference necessary to Judge York's findings, and that her legal conclusions are correct. She specifically visits on page 12 of her opinion, which is in the record at 161, the procedural versus substantive aspect of this claim. And she specifically finds that it cannot be something that is retroactive. She states specifically that it's difficult to characterize as procedural. And Judge, and it's our position that that was an appropriate finding. I think the body of this and what the appellate is complaining about with respect to, and again, the focus of this is the assistance of counsel. And if you take a step back from it, essentially what the appellate is doing is saying that Ms. Erickson, with respect to changes in the law, would have had to have been clairvoyant. That's far beyond the standard of review that we're used to in ineffective assistance of counsel claims. And that standard of review does not require ever counsel to anticipate changes. I think that's a real reach. And Ms. Erickson's conduct certainly would never have been, she would never have been required to be clairvoyant in figuring out what the law would have been, or what the law could be, and what the legislature would change the statute to in the future. And I'd ask that the court uphold Judge York's opinion.
Any other questions? Thank you. Ms. Phillips, we're ready for your rebuttal. You still have your full 2 minutes.
With regard to conceding, I'm going to take great issue with that. Mr. Smith and I had several conversations on the phone about how to get ADT onto the grid. There was never any argument ever made that this was not an unconstitutional sentence. We had conversation after conversation. We went to the judge. We put this on the record. And the reason we did that, and the reason he agreed to putting him on the record or pleading him down to the second degree, was because they agreed that the sentence was unconstitutional. There has never been an argument made until this very moment that they were not conceding that the sentence is unconstitutional. And it's not just Miller we're asking you to apply, because we understand that there are some issues with Miller, but you look at the Freeman factors based upon the concepts that are set out in Miller about how juveniles function. And you look at those Freeman factors, and that first one about the reason they commit the crime, the degree of their culpability, their degree of propensity for violence, all of that cuts against ADT. I take issue with this being an unmotivated killing that was execution and random. This was a child who was plied with alcohol and drugs by an adult, put in a car by an adult, given that adult's gun. The adult picked out Mr. McElroy. The adult said to ADT, pull the trigger. This was not ADT just out randomly killing people for the sake of killing people and for a thrill. This was all orchestrated by an adult. And that falls right within the parameters of Miller, and that falls within the parameters of Freeman. And the state doesn't understand that this is not what we're arguing here, and what they have said from the beginning is that because of that, they've conceded that this is an unconstitutional sentence. So giving deference to Ms. Erickson, we don't give deference to attorneys who don't understand the law. We don't give deference to attorneys who don't know the law. She has an obligation to know the law. Kimmelman versus Morrison says that's classic ineffective assistance of counsel. You have a Kansas Supreme Court opinion where they are trying their best to find due process violations. They're trying their best to put this into constitutional context. Listen to that argument where Justice Stegall is saying, so is there a due process violation here? They are trying. And you have Justice Rosen's concurring opinion saying, man, she gives us nothing. If she would have argued the Eighth Amendment, if she would have argued due process, if she would have argued that this was a cruel and unusual in this instance, we could have reversed this. And that is sufficient to meet the ineffective assistance of counsel standard that's set out by Strickland and set out by Holland. And those are going to control. You don't give deference to her. And yes, you may give some deference to the fact findings that were made by Judge York, but how those facts are applied to the conclusions of law is reviewed de novo, and you are in just as good a position to make those assertions or those assessments about ineffective assistance as just Judge York was. In terms of not asking Ms. Erickson to be clairvoyant, she didn't have to be clairvoyant. The case was pending when the statute changed. The opinion was not down yet, and the statute was different. If she would have paid attention and said, oh, I'm a juvenile attorney. When there are changes to the juvenile law, I should probably know about them. And when they come down on July 1, they now apply. And if she would have read that, she would have understood that that applied to ADT, because that has always been our law. Our law has always been that the case is not final until the decision is issued, and the decision had not been issued. She didn't have to predict into the future. Those facts and that law already existed at the time, and she failed. She failed to argue Eighth Amendment violations. She failed to argue about the constitutionality of not providing rehabilitation. All she said was it's unjust, and she's right, it's unjust. But it's not unjust just because it's unjust because it's unconstitutional. And she needed to have made those arguments, and her failure to do that resulted in this revocation and the imposition of a 25 to life. That's not how our system of justice works. This case needs to be reversed. We need to send it back. The sentence needs to be vacated, and a different sentence besides 25 to life needs to be imposed. Unless you have questions, I'm probably out of time.
I don't see any questions. We appreciate both of your arguments. We will conference this case and try to get you an opinion as soon as possible. Thank you very much, and this matter will be adjourned.
Thank you.